All rise and be silent. The Honorable Judges of the Intermediate Court of Appeals, Chief Judge Thomas D. Starr presiding. Oh yay, oh yay, oh yay. Silence is now commanded under penalty of fine or imprisonment while the Honorable Judges of the Intermediate Court of Appeals are now sitting. Let all persons having a motion to make an appeal to prosecute come forward, you shall be heard. God save the state of West Virginia and this honorable court. Please be seated.
Good morning, everyone. We have two cases on the docket this morning. If the clerk would call the first case.
The first case on the Rule 20 argument docket is Gray Media Group Incorporated doing business as WSAZ versus the West Virginia Department of Health and Human Resources. Appeal number 23 ICA 283, an appeal from the Circuit Court of Kanawha County.
Counsel, ready to proceed?
Yes, Your Honor. Thank you.
This is a Rule 20 argument. You have 20 minutes per side. Petitioner may reserve a certain amount of time for rebuttal if you choose.
Thank you, Your Honor. I would like to reserve 8 minutes, if I may, for rebuttal. 8 minutes, if I
Thank
may.
you.
Matthew Cate for Gray Media. Also, I'll refer to them as WSAZ or the station. And before I start, I would like to just emphasize or point out that we are joined today by several representatives of WSAZ. We have Mr. Joel Swisher, Executive or Vice President and General Manager, Anna Baxter, News Director, and Kristen Bradley, Assistant News Director. And I want to point that out just because, as the Supreme Court of Appeals has recognized, the press stands in the shoes of the public and the public's effort to become informed about what's going on in their name. And I just think it's a nice illustration that they're here today to emphasize the importance of the issues we're talking about. And with that introduction, may it please the court. Should probably start that. The people of West Virginia have made it clear that they insist on remaining informed about the operations of their government and about the conduct of the public servants who carry out those operations. And so through the legislature, they've codified a transparency imperative that the courts of this state are required to serve and apply as broadly as possible in favor of disclosure. At the same time, the people of West Virginia did recognize that in limited circumstances, there are interests that sometimes warrant not disclosing public records. But the people of West Virginia have made clear that those statutory exemptions are to be narrowly construed and strictly applied. And in all instances, disclosure is the rule of the day. The circuit court erred in this case by turning these presumptions and this fundamental public policy of the state of West Virginia inside out. It incorrectly overvalued the interests of a high government official in his alleged personal interests in the conduct of his job that he did for the people of West Virginia, while at the same time devaluing the public's interest in their right to know. And an important principle that order failed to take a proper consideration of is the fact that the people of West Virginia said the qualitative assessment of what we are interested in is to be made by the people of West Virginia who make the FOIA request. The people behind me, for example, who stand in the shoes of the public in finding out information. They decide what's important for them to know. And in fact, this is codified in the FOIA, in Section 1, that it is not the role of public servants to tell the people of West Virginia what's good for them to know and not good for them to know. And in this case, the ultimate question is really, would this disclosure of the public record, the termination letter at issue, constitute an unreasonable invasion of privacy? That's the exemption at issue. The Supreme Court in Klein has made clear that that unreasonable invasion of privacy is synonymous with a substantial invasion of privacy. And we have the 5 factors that we've briefed and the court's familiar with that gets us to this question of, would this be an unreasonable invasion?
To what extent does the circuit court's finding should we owe any deference to that as an appellate court?
Well, Your Honor, the findings, the FOIA cases are reviewed de novo on the record in the case. And so if there are factual findings, then those are to be considered with the discretion that the court applies to those factual findings. But in this case, there aren't any factual disputes of which I'm aware. But the overall application of these fundamental principles of the FOIA, this is something that the court takes anew on its own. And, you know, on the point of factual findings or burdens here, I should step back and make clear that while the department has discussed this concept of a clear and convincing evidence standard, that doesn't apply in the initial analysis of whether there's a substantial invasion of privacy. The statute asks three things. First, does the public record implicate information of a public or personal nature? If it does, then the question is there a substantial invasion of privacy?
You concede the first point, though, that it's something that would normally be in a personnel file, as A2 talks about.
We understand that the termination letter is something that goes in a personnel file. This does implicate an individual's name, potentially an address, and some information relating to a person. So it does trigger the analysis if it's invoked, and it has been in this case. So then the next question is, as the court in Klein explained, is this a substantial invasion of privacy if it's disclosed? Part of that analysis to answer that question is the privacy interest identification of what's at stake for the personalized, intimate information at stake, assuming there is any, and then the public's interest in disclosure. And if you reach that, if you make that analysis and then the other factors, alternate source, expectation of confidentiality, and you determine there's not a substantial invasion of privacy, this clear and convincing standard does not come into play. The statute is written such that if there is a substantial invasion of privacy, then you look and see what's the ultimate weight here of the public interest versus private interest. And if you have a clear and convincing need for disclosure, you then override and you're less concerned about the substantial invasion of privacy.
Let me ask you briefly to go back to the issue of the burden. My understanding is we have a FOIA statute that requires disclosure. There are exemptions, and the public body has the duty to establish the exemption. Starting point. What's unusual here is we have, both in the statute itself and by case law, at some point in the analysis, some balancing going on. Do you believe that the burden shifts from the public body to the party trying to enforce the FOIA disclosure, or does it go from the initial burden and then becomes a balancing where neither party has an affirmative duty and burden?
I think it's the latter, Your Honor, because in all instances, as Your Honor recognized, it is the burden of the agency resisting disclosure to establish the exemption applies. If in the analysis the court considers, and we made a showing in the record of the public interest, and we're allowed to, of course, make our record the best we can. And when you consider these competing interests, there is potentially ultimately this weighing of would this justify a substantial invasion? But it's not our burden to show that the public interest substantially outweighs the privacy interest. We better try, and I think we did, and we established that. But it is in all instances the burden of the agency to show that the privacy interest exists and are cognizable, and that the public interest is lesser than. But we address that in our papers. And when you look at what the parties introduced in evidence in the court below, you see a 5-paragraph or so declaration from a general counsel that doesn't discuss any of the issues we're talking about today. There's no evidence from the department that the letter terminating this high government official was created with, this an antagonistic letter, you're fired. There's no record from the department that anybody created that with the expectation that it would remain confidential. There's no evidence in the record that it has remained confidential. Meanwhile, we put in evidence that showed that this was an issue that was front and center in the public's mind, and the governor's mind, and the department's mind. What's going on with how is this department carrying out the honest and efficient operations? And I use that phrase because that's the phrase that the court in Klein used to discuss this public interest of finding out information to ensure that there's the honest and efficient operations of government. And in that footnote in Klein, the court said that interest is overwhelmingly important in FOIA cases and should be, places a heavy thumb on the scale in favor of disclosure. And so when you have that factor, you know, and then the efficient operations of government, I should make clear, this isn't just about Mr. Samples. This is also about the department and what the department was doing and how it treated its high-level employees, what it decided was important for the department to do and not do in the name of the people of West Virginia. So this isn't just about the reputational interest of one man. It's about the operations of a government entity. And about those reputational interests, the only issue that's supposed to give rise to this privacy interest, according to the department, is this potential for embarrassment if it's known why the department alleged Mr. Samples was being fired. But Mr. Samples' reputation as a public servant belongs to the people he served. The people of West Virginia are entitled to know why their own employee, whom they entrusted for 20 years nearly at the department, whom they encouraged with, you know, salary and increased responsibilities, why he was fired in their name. And when you factor those, you know, weigh those together, there's no privacy interest at all here of the type we see in Klein. There's no mental health records. There's no initial evaluations of the type in Smith versus Bradley. The initial evaluations in that case were used to reach, presumably, employment outcomes, employment status determinations. The evaluations were what was at issue in Smith versus Bradley. Here, in this case, we have the ultimate determination. And that's what distinguishes this case from the others where you have intimate, personalized information.
Let me ask you to address a couple things. What is your position on the impact of the inadvertent disclosure of the draft termination letter? And then secondly, what impact, if any, does the amount of public discussion by the various parties, including Mr. Sample, have, if any?
Thank you, Your Honor. The disclosure of the draft, it has an impact on this case and its analysis because I now at least have some insight into what was considered before the final version. I don't know what the final version looks like. Of course, Your Honors do. It shows that there was some consideration of misconduct that was at least initially written down of that misconduct that affected the operations of the department. I mean, that's written into the draft. Now, if the draft looks completely different, the people of West Virginia deserve to know why it changed or what changed. If he was in fact alleged to have been, you know, inefficient or doing things that he shouldn't have or violating the employee handbook, but then the department changed its mind and fired him from other reasons, the people should get to know that. On the second question, the impact of the public statements, that shows that this issue is out in the public, first of all. It shows it was a matter of public importance. Governor Justice made statements about it. Secretary Crouch, they obviously didn't discuss in detail the reasons Mr. Samples was terminated, but they discussed the issue because they recognized and they were asked about it because it was important to the people of West Virginia. Mr. Samples released his own statement, and he mentioned that there was a disconnect, at least internally. That's what his statement was about. We need to be on the same team, and we're not on the same team, and I'm proud to have served the people of West Virginia. This tells the public, opens the door to the public's interest and the essentially a waiver of some level of privacy by discussing, I'm not employed there anymore. We have a disagreement. And that disagreement is the only basis for termination that the department acknowledges in its brief, is that there was a policy disagreement. This isn't serious misconduct. And I'll probably discuss that more in rebuttal, this notion of serious misconduct. But one question I have is if it's not serious misconduct, why was he fired? And if it's not serious misconduct, how would that implicate his potential for embarrassment? I'm happy to answer more questions, but I would like to reserve, the remainder of my time, or if there's a couple of minutes worth of questions, I'm happy to entertain them now.
Thank you.
Thank you.
Thank you, Your Honors, and may it please the court. I'm Lindsay C. here today on behalf of the department. Let's start with where we all agree. FOIA is an important pro-disclosure statute, and exemptions must be construed narrowly. The department does not contest any of that. But Where one of those exemptions applies, the legislature has expressly carved that information out from the pro-disclosure default, and this exemption in particular operates in a unique way. It's not one of the exceptions that protects the state or the agency from information that it thinks might harm it if it goes out. This is an exemption that's designed to protect the privacy interests of individual West Virginia residents. And here, two jurists below, the Discovery Commissioner and the Circuit Court, reviewed the facts in this case, weighed them using the case-specific factors that the Supreme Court of Appeals has laid out, and determined that disclosure is not required in the public interest under clear and convincing evidence. And WSAZ cannot give this court any reason to overturn that fact-bound and discretionary judgment. So I think I'd like to start where opposing counsel spent a lot of time and where some of the court's questions are, because I think it's very important for us to understand the nature of the inquiry for this exemption and the type of task that the Circuit Court was tasked with, and then by extension what this court is doing when it reviews on appeal. So let's look first at the sort of balancing that's involved here. Opposing counsel is correct that usually there is no balancing in a FOIA context, but this is an area where that's different. The Supreme Court of Appeals said in Klein it recognizes that it actually makes this an odd sort of exemption. Usually, if it's just an on-off switch for an exemption. If the exemption doesn't apply, the information goes out, and it doesn't matter why or the purpose. That's not true here. The court said that in Klein, elevated to syllabus point 6 in Smithers. So what we are doing is a balancing test that's different from other FOIA contexts. But Klein actually went further and said this isn't just even an ordinary balancing test. This isn't a circumstance where we put privacy on one hand, public interest on the other, see which one's heavier, and then a question, the analysis is over. Klein actually took on this question and it compared our privacy exemption to the federal exemption. And the federal privacy exemption for FOIA is similar in a lot of important ways, as both parties agreed throughout the briefing. But Klein explained it's different in an important way. The way the federal exemption is written, if it's a close case, the default is in favor of disclosure. That's not true for our exemption. Klein expressly held that if the scales are even, or even if they're close, our default is on the side of privacy. And that's something that comes expressly from the statute itself. There are 23 FOIA exemptions. This exemption, too, is the only one where the legislature put a particular evidentiary burden before the information goes out. Now, we do agree, of course, there is the threshold determination whether there's a substantial invasion of privacy, but after that's shown, there has to be clear and convincing evidence in the record that the public interest requires disclosure. We don't see that in any other part of our FOIA law, and that's why Klein said that, again, if this court at the end of the day thinks it's a close cases are on the side of protecting that individual's privacy.
Let me ask you, first, where in the analysis does this go? In 2008, in the Gazette case, there was a distinction between information of a personal nature, intimate nature, given to the government for one reason or another and held, presumably, in a personnel file,
Right.
versus information created by the public.
Right.
Where does that factor fit into the analysis?
Absolutely. So we have two tests here. We have the statute itself that says we're looking at the invasion of privacy and then the public interest. And then in Klein, the Supreme Court gave 5 factors. I think that particular one about information with an expectation of privacy, that's Klein factor 4. And that, I think, goes to this first question of the nature of the privacy itself. It's not a dispositive factor, but it is a factor that plays into that first question. So Klein 4 about whether the information is given with an expectation of confidentiality. It goes with Klein 1 about the severity of the privacy invasion itself. So both of those get into the analysis on the first part. I think while we're talking about that exemption 4, it is true that Klein talked about information that's received by the government, because that was factually true in that case. Klein or no other case went forward to say that's the only time when that expectation of confidentiality applies, that it, in other words, that it can't apply when the government itself is the one who creates the document. We just don't have any cases that go that far. And actually, if we look at the Smithers case, which also looks at Klein factor 4, it looks at a different legislative rule that has an expectation of confidentiality. And the Supreme Court in Klein said that, again, factor 4, it's not going to be dispositive on its own, but in fact, it would have been legal error under Klein for the circuit court here not to consider the particular legislative rules that require confidentiality for personnel files. That's what Klein held, that the court has to give due regard to those separate statutory rules. That's what the court did here. Again, I'm not arguing that that's dispositive on its own, but it's a required part of the analysis.
You'd acknowledge that the statute overrides the legislative rule. You're just arguing that it needs to be considered.
Well, I do acknowledge that if there is a conflict between them, that I think that we have a much harder case there, but we don't, because I think, if I'm understanding opposing counsel's argument, they say the conflict between the legislative rule about confidentiality is that FOIA has a presumption in favor of disclosure, but they don't look at the rest of the FOIA statute. It is true, there is that general presumption. Again, we are not fighting that. But in the preamble and in subsection A that talks about the exemptions, both of them say except as otherwise provided by law. And the preamble to 4, which talks about the exceptions, also says that these particular categories are carved out specifically from that presumption. So if we're in an area where the privacy exemption applies, then that overall presumption for disclosure doesn't by definition. So we just don't have a conflict between the two, especially when the Supreme Court of Appeals has told us that it is a required part of the analysis to look at other laws like these legislative rules that indisputably require confidentiality here.
How do you distinguish Smithers 2013 case that talks about the job performance in the state police?
Right.
Seems very similar to what we're talking about here.
It is similar in some ways. I think there's a couple of things we need to look at. The first is just dividing up the two parts of the analysis. What Smithers didn't say about the privacy interest. It did not say that there is no privacy interest at all here. It does say it distinguishes between on-the-job and off-the-job performance interests, and says that one has less of a privacy interest there. It does not say that there's no privacy interest at all. And the reason we know that is because if there's no privacy interest, there would have been no need to go to the second part of the analysis to figure out how strong the public interest is.
You don't go to the second part of the analysis unless there is an unreasonable
Correct.
privacy, not simply a privacy interest.
Exactly. And I think that's an area where we do have a bit of a difference, because there in Smithers, the Supreme Court recognized there is a privacy interest, but it was lessened, and there was a greater public disclosure interest. And I can explain why both of those are different here. But again, I think it's also important for us to step back and recognize the posture we're in right now. The Circuit Court was tasked with balancing these inherently imprecise factors. And the question now is, did the Circuit Court abuse its discretion in the way that it did that? So again, this isn't a question of whether this court might, on a blank page, reach a different result.
Well, isn't it though? Because if we have a de novo review, we have a de novo review. I mean, if we're going to apply the facts to that balancing test, I might disagree with you a little bit there. Do we owe discretion to how they came out on that balancing test, or do we do this de novo and we're to run that balancing test ourselves?
You do, Your Honor, owe discretion, and let me take a run and explain why. I think if we look at the statute that opposing counsel cites in their brief, that statute does say de novo. But what it says is that when a party brings a FOIA action, the first court to review it gives de novo review. What that means is the department doesn't get any sort of deference to the initial decision it made. We don't fight that. In the Circuit Court, that was de novo review. But what that statute doesn't say, and none of the Supreme Court's decisions say, is anything changes about the nature of appellate review. In fact, if we look at the particular the case that was cited that talks about de novo review, that was reciting the ordinary summary judgment standard. Summary judgment is reviewed de novo, but it's also true, as opposing counsel recognizes, the legal parts of that summary judgment are reviewed de novo. Opposing counsel just doesn't explain it. In fact, I actually heard opposing counsel to concede that the other part of any factual findings found up get the ordinary clearly erroneous review. So we're in a circumstance where we have initial de novo review. The department doesn't get that extra thumb on the scale, but appellate review operates the same way that appellate review always operates. And we cited the Canterbury decision that talks about the fact that even in a FOIA context, factual decisions get the ordinary, clearly erroneous standard. And it's important, again, to look at what's the question that the Circuit Court was tasked with. It was tasked with an inherently discretionary judgment, weighing all of these factors. We can step back again and see what Klein said about this particular analysis. This question of why can't FOIA be easier? Why can't we have bright line rules? That's something that's come up a lot. Klein addressed that specifically and essentially said, it would be great if we could, but we can't, because these sort of things involve inherently imprecise judgments and weighing things that are just not going to be susceptible to a bright line rule. And then what Klein said is the consequence of that is that the Circuit Court needs to have discretion when weighing them. So we have the Supreme Court telling us that this is an inherently discretionary judgment. That's what the Circuit Court was supposed to do, and this is how this court should be reviewing that judgment on appellate review. But again, even if, Your Honor, if you disagree with me and this is viewed as totally de novo, it would still be de novo of looking at this balancing, inherently fact-specific judgment. And again, if at the end of the day we're left with a close case, Klein tells us that close case is to err on the side of privacy.
In considering both the initial inquiry of whether there's a substantial, privacy interest, and also in the balancing test, isn't it necessary to, whether we're the trial court or whether it's us reviewing it, isn't it necessary to look at what information is out in the public domain? I think you cite a case on page 15 of your response brief, Public Citizen versus Department of State. The fact that specific information is in the public domain can undermine a privacy interest, but only when it duplicates that being withheld.
Right.
Doesn't it become important for us in reviewing this to see whether any potentially privacy information is already out there, whether in the form of the inadvertently released draft or whether in the form of statements made by Mr. Samples, or to the extent that it's already out there, doesn't that diminish the privacy interest, and doesn't that require us to determine whether there's a difference between the final letter and the draft letter?
Your Honor, I think that is relevant, yes. I am not disputing that what's already in the public, whether from Mr. Sample's statement or from the inadvertent disclosure, I'm not disputing those are relevant factors. But they're not enough to change the analysis here. And I think we can look at first Mr. Sample's statements. He did in fact acknowledge that the termination occurred. That's true. The fact of the termination, there is no longer a privacy interest in that to the extent that ever was a substantial privacy interest. There's the case that you noted in our brief. We also relied on the Kimberlin and Citizens for Responsible Ethics decisions that both make the same point in the context of investigations for wrongdoing. It says the fact that an investigation is ongoing is different. That's a distinct interest from the contents of that investigation and decision. So acknowledging the fact of the termination does not change the privacy interest in the reason for it. And then I think we get to the inadvertent disclosure here. The error in releasing that document doesn't waive Mr. Sample's privacy rights, because the Supreme Court has said that we have to look at the purpose of this exemption. That's what Mann and Robinson and Smithers all say. The purpose is to protect individuals from harm and embarrassment. And so we have to look at both the draft and the final from that privacy-focused view. From Mr. Sample's perspective, there is a particular privacy interest whether the draft is released and whether the final version is released.
Well, if the information, I mean, there's two possibilities. Obviously, that's either the same information or it's different information, and without getting into which it is, but isn't that important? If there's no new additional information, how can there be further invasion of privacy if the information is already out there?
Because I think if a final draft is out there, that is a different sort of harm. Because what it does is says this is the actual reason that the agency gave, this was signed off, this was approved. This was not some sort of internal discussions that somebody decided there was additional information later that could have changed the result. It is giving the official agency response.
Well, if
And I
that's
think-
already out there, then what difference does it make?
Because it's not already out there, Your Honor. I take the point that the draft is out there, and I recognize that that is relevant to the analysis. But the difference would be having a final letter out there that says, this is the official reason why this person was terminated from the department. That's different from discussion that went around ahead of that decision. Having that official confirmation is itself a substantial invasion of privacy.
Well, doesn't it raise the issue that whatever is in the final and the draft may not be the actual reason, that it could be an effort to scapegoat? I mean, isn't the public entitled to be able to weigh what the department said was the reason compared to what Mr. Samples has said publicly is the reason? There may be significant differences, and that part of the whole purpose behind FOIA.
I think there's two responses to that. The first is the very fact that there might be significant differences is why there's still a distinct privacy interest for Mr. Samples in not having the final release. But the second answer goes to this question of what the public interest is. Opposing counsel argued that the public has a right to know. And of course, generally speaking, that's true. That's what the legislature said in FOIA. But it also said that that presumption gives way when these particular exemptions apply. So this is a circumstance where the legislature said the public has a right to know only if we have clear and convincing evidence that it is required. So this is not, we are not contesting the fact that a general interest in what the government does or accountability isn't important. That's very important, and in most FOIA cases, that's going to be the end of the analysis. But in this case, the legislature said if we're dealing with something that has a substantial invasion of personal privacy, there has to be more. there has to be a showing of clear and convincing evidence that not only that the public might want this, but that the public interest requires it. And the Supreme Court has applied this public interest exemption a number of times and has said what that means in this privacy context is there has to be particularized and evidence-based justification. It can't just be this general, the public has a right to know, or newsworthiness. What the court has said in Klein and Smithers is that there's a couple of ways that this plays out. Whether there's pecuniary interest in how tax dollars are being spent and misused in a direct fashion, or whether we have something that goes to the public's rights and liabilities. That's what we saw in Klein, for instance, which involved the bus driver, where there were very serious concerns about school children's health. The Supreme Court said safety of kids is of paramount importance, so we had the public's rights to have a safe transportation option for the state school children. That was directly implicated there.
You would acknowledge, wouldn't you, that the effective operation of DHHR would certainly implicate both financial issues and service issues to the citizens of the state?
I do think it does at a particular level of generality, and that's not me avoiding the question. I think that's important because I think this idea of the public dollars are being spent and the way that the public has their government responding to them and providing services, that's going to be true in a huge number of FOIA cases for any number of agencies. If that's the standard, how government officials are doing their job in ways that matter to the people of the state, then the privacy exemption is essentially swallowed up. And that's why the Supreme Court has always required more than that. It says it cannot just be this generalized interest in what the government is up to. Again, that's enough for FOIA generally. The department recognizes that. We're not disputing that. But in this unique exception, where the legislature has required clear and convincing evidence that the public interest requires disclosure, that generalized interest isn't enough.
Let me ask you, whatever the differences may be between the draft and the final version of the letter, is it your position that those differences, if any, are significant?
The department's position is that confirming the final reason for termination, that itself would be a substantial invasion of privacy. So in some sense, it doesn't matter whether there's differences or not. Knowing the actual reason is itself has a high potential for embarrassment and harm to Mr. Samples. And that potential for embarrassment and harm is the standard that the Supreme Court has given us time and again for what counts as a substantial invasion of privacy.
When Judge Ballard let the temporary, or I guess, injunction concerning the inadvertent disclosure expire, was there an effort by the state or any non-party to file a writ of prohibition to try to preserve the fact that, you know, if we were to concede your argument that the cat became out of the bag in some ways inadvertently?
The department did not go forward, and some of that was a strategic judgment based on the different standard that admittedly applied at that point. We understood, and we of course took immediate steps to try to stop that disclosure once we found out that it had gone out. But once the circuit court issued the order that talked about the much heightened standard for First Amendment protections, the department didn't go forward. I think it's also important to recognize that Judge Ballard allowed publication immediately. So even though there had been a stay to allow us to have those proceedings in circuit court, there just effectively wasn't time to have heightened review. But even so, I think that the fact that Judge Ballard recognized that after the inadvertent disclosure had occurred, that we couldn't unring the bell, that doesn't change the analysis here, because we're dealing with a different standard. We're not talking about the prior restraint First Amendment context, which is one of the highest standards ever. As Judge Ballard recognized, the U.S. Supreme Court has never approved a prior restraint. So we're just dealing with something very different. And even Judge Ballard recognized that it didn't change the ultimate decision, that the department was entitled to withhold the draft in the same way that the department is still entitled to withhold the final letter. That's the analysis we have here. We have a circuit court who looked at all of the facts, who did the sort of balancing that the Supreme Court requires, and found that there's just not clear and convincing evidence that the public interest requires disclosure. This court should affirm.
Thank you. Counsel, you have 8 minutes.
Thank you, Your Honor. 4 seconds left. Sorry, I'm trying to clear it out.
It's a guide. That's all.
And I'll put it at 7.
All right.
To address a couple of things, Your Honor. First, starting with this concept of there being a close call and there being a need for clear and convincing showing of disclosure when there's a close call. That's what it says. That's what counsel said. That's what the Supreme Court of Appeals did in Klein. We don't have a close call here. We don't have a substantial privacy interest beyond, once again, the notion of what reputational interest does a high government official have in the performance of their duties as a public servant. This isn't mental health records. This is not personal financial information. This is not a close call. We don't get to this clear and convincing weight. Related to that, there's a difference between the public's interest in disclosure and the ultimate decision on whether the public has a right to know about a particular document. The fundamental policy of this state reflects that the public is interested in the full and complete information. Yes, there are exemptions sometimes that stops the public from fulfilling their right to know, but that doesn't mean they don't have an interest in that information. And the court has to take into account that interest when it's doing the balancing here of the privacy interest, of the public interests. And so we don't start anew, in other words, whenever we have a privacy case, we don't start from scratch. This fundamental transparency imperative, that is the policy of the state, has to inform the analysis of the weight. Second, I want to address this court's review and the standard at issue here, and a couple of things about Smithers that were just discussed. This court has de novo review. The court in Smithers made clear that FOIA cases are treated like summary judgment cases. We, in fact, filed a cross motion for summary judgment. The department labeled theirs something a little differently, but it's the summary judgment standard. And in fact, there are no disputed issues of fact here. I can't dispute what the content of the letter is. We don't dispute that Mr. Samples was fired. There's no dispute of fact. The only deference this court would give to the trial court below is on the findings of fact that resolve dispute. Judge Greer was correct that the analysis that this court takes anew the question of the factual issues and how they fit into this analysis. That's a de novo review. Smithers made that clear. Every other FOIA case makes it clear that this is de novo review. Another issue that Smithers that is worth emphasizing in Smithers is that, in fact, the Supreme Court of Appeals did make a bright line rule. Syllabus point 8 says state police officers do not have a privacy interest in the details of the performance of their public duties. That is written right there in Syllabus point 8. It was a specific holding of that court. And then it went on to assess the other factors. And I heard counsel to say they didn't need to do that, or that they needed to do that because of the overall analysis here. I submit that they didn't need to do that, but they did anyway to give further guidance. And I know that they didn't need to do that because a few years later in Highland Mining, the court had a privacy assertion in front of it, and the court said there's no privacy interest in these particular materials in front of us. We're not engaging in the rest of this 5-factor analysis. So in Smithers, the Supreme Court made very clear that at least certain public employees have no privacy interests in the performance of their duties, full stop. Now, Mr. Samples and Secretary Crouch and other high government officials presumably don't go to work with a badge and a gun, but their impact on the people of the state is profound and very real. And that rule from Smithers should be extended to these types of public officials who are carrying out these duties at the highest level and at the highest pay. Excuse me. And so, these issues, that lack of public, or rather private interest in the performance of Mr. Samples' duties, when you set that stage and you set that table, you recognize that this is not a close call. And especially when you then have to consider, as I mentioned at the beginning of this rebuttal, the public policy implications that a requirement that the people are interested in this information. The people have asked this court through the FOIA to engage in this analysis, but they didn't discard their interest in this information. They said it's not for the public servants to tell us what we're interested in. Now it's for the department and it's for the courts to analyze ultimately whether we get this record. But the people of West Virginia are interested in this information. They've requested it and they're entitled to it. And flipping the standard to require some other showing here by the public would just turn that policy on its head. It really is this simple. The people of West Virginia hired this man. They hired his superior. They entrusted them to carry out these important public duties, and then they fired him through their other representatives in the government. Can it be consistent with the fundamental policy of the state that the people of West Virginia can, through their intermediaries at the department, fire a high government official but not be told why? That's not the FOIA. That's not the law. And with that, I've got about a minute and a half. Happy to answer any further
The
questions.
state argues that the fact of relative to the inadvertent disclosure of the draft document, the state argues that any information in a final document, just because it's the final document, is a new and different privacy interest regardless of any difference in the contents. Do you agree with that or not?
No, if the final document looks anything like the stuff that was discussed in public, then there's no privacy interest. If the final document looks different than the draft letter, as the court has said, the public deserves to know and compare what was thought about and what was said and what's now in the public sphere versus what was finally said. The people of West Virginia get to assess what happened and make up their own minds.
Let me ask you, what if we have a reverse situation, that the final version is either inadvertently or intentionally disclosed? Would it be your position that under FOIA you're entitled to drafts of that letter?
That raises a much more difficult issue. Under the privacy exemption, I would say no. I'm not going to pretend that there's not other exemptions that may apply to drafts. They were litigated in this case in other contexts and other public records. But I think full disclosure is the rule of the day and the policy of the state. And I think whenever you have some information, finding out more is what this court has been instructed to try to do here. And the people of West Virginia deserve to know.
Thank you very much. I think we understand your position. The case will be submitted. Thank you.
All rise, remain standing while the judges leave the bench.
Is counsel ready to proceed?
Yes, Your Honor.
Next, first up on the Rule 19 argument docket is Lisa R. Daniels versus DAL Global Services LLC, appeal number 23 ICA 212, an appeal from the Circuit Court of Kanawha County.
This is a Rule 19 argument, but by order of this court, the parties have been allotted 20 minutes per side. So, Mr. Ensmeyer, you may proceed.
Thank you, Your Honor. May it please the court. DO Global, the respondent in this case, prevailed on its motion for summary judgment below based upon the utterly false claim that our client, Ms. Daniels, was an illegal drug user. Lisa Daniels lived in Proctorville, Ohio. She commuted for 9 years to the Yeager Airport where she worked as a ticketing agent. In August of 2020, she was granted disability leave to undergo carpal tunnel surgery. Part of her prescribed treatment involved using medical marijuana for pain. It was usage that was legal under the state of Ohio law. It was in accordance with a lawfully issued medical marijuana card. And there's no evidence to the contrary that all of that was legal. When she prepared to return to work, she was required to take a drug test. And she provided documentation to DO Global to demonstrate that she had a medical marijuana card and that any testing that was done that would detect marijuana would be the medical marijuana that she used legally in Ohio. The medical review officer, who was retained by DO Global to review this test result, certified that Ms. Daniels had advised that she had a medical marijuana card, and he alerted DO Global to the fact that there would be state laws and company policies that may affect and excuse a non-negative test. And frankly, repeatedly, Ms. Daniels not only requested an accommodation, she begged that she not lose her job because she had lawfully used medical marijuana. Notwithstanding all that, DO Global ignored those requests, and it summarily fired Ms. Daniels. She has filed a complaint. She filed a complaint alleging multiple causes of action relating to her wrongful discharge: disability discrimination, failure to accommodate, unlawful retaliation, claims for violations of the West Virginia Medical Cannabis Act, a harmless claim, and also common law invasion of privacy claims. The parties conducted extensive discovery in this case, and the parties filed cross motions for summary judgment. A motion for summary judgment hearing was scheduled, unfortunately had to be canceled. Sadly, these proceedings were being undertaken at the same time that Judge Tabbitt had entered into her battle with terminal cancer. After the hearing was canceled, parties were invited to submit proposed findings and conclusions. 8 days later, the judge entered an order granting the motion for summary judgment for DO Global, accepting all of their proposed findings and conclusions, and ruling as a matter of law that all of Ms. Daniels' claims would not be allowed to proceed to a jury trial. She timely filed a Rule 59E motion to alter, and that motion was summarily denied. We are here today, Your Honors, because we respectfully submit that the proposed findings that were submitted by DO Global and adopted by the court are replete with legal errors. In defending this case, and this is critical, the crux of their case is they have fabricated a rationale. DO Global fabricated a rationale for having fired Ms. Daniels, and then they concocted a bogus legal argument to justify that rationale. DO Global's internal documentation clearly shows why Ms. Daniels' termination was approved. The ultimate decision maker in this case was Kevin Ingham, the peaceable officer in Atlanta. There's no question he is the gentleman who issued the ultimate edict that said that her termination should be approved. Nowhere in the DO Global's briefing will you find any reference or acknowledgement that Mr. Ingham even existed. But in his 3-sentence email, he makes it very clear. He is approving her termination because he believes, wrongly, that she has reported to work under the influence of marijuana. And notably, in that email, he acknowledges that he has no problem with the fact that she'd used medical marijuana in accordance with a medical marijuana card. He states, quote, "A medical card permits an employee to legally use medical marijuana." Now, there's no evidence, and DO Global's fully aware, there was no evidence that Ms. Daniels had ever reported to work under the influence of marijuana during her 9 years working at Yeager Airport. And the usage for which she was being tested in this case had occurred, undisputedly, while she was out on extended disability leave, and she never was permitted to return to work. Instead of admitting Mr. Ingham's obvious mistake, DO Global doubled down and made up an entirely new argument for why it had fired Ms. Daniels. It claimed, and has continued to argue throughout this case, that she was an illegal drug user and that she deserved to be fired because she had violated company policy that said possession, use, sale, or manufacture of any illegal drug will result in termination. Now, there was extensive discovery, over a year's worth. And no question, DO Global tried its best to uncover evidence that Ms. Daniels, from her past, that she was guilty of some kind of illegal drug use. but the evidence uncovered no such evidence. There was absolutely no evidence to show that Ms. Daniels had ever illegally used marijuana or any other drug in West Virginia, Ohio, or anywhere else. Again, instead of admitting that it had no evidence to support its newly found claim, DA Global doubled down again, this time by concocting a legal argument for which there is no basis in law that basically says it doesn't matter that her use of medical marijuana in Ohio was legal. What matters was she was being viewed under the viewpoint of West Virginia law when she took her test. And the applicable conclusion of law in this case, it became the crux of their case, is found in paragraph 50 of the court's final order. That paragraph adopts verbatim the one-sentence conclusion of law that was submitted by DA Global, and it states any marijuana in her system was not legal in the state of West Virginia, and any drug test for marijuana in West Virginia would have been testing plaintiff for an illegal drug in this state.
Counsel, would you acknowledge that there's a difference between being an illegal drug user and simply violating a absolute drug policy that prevents anyone from having any drugs in their system?
Well, the policy that they claim was violated specifically refers to illegal drug use. The word illegal drug use is in the policy. Possession, use, sale, or manufacture of any illegal drug will result in termination. So in order to prove that she deserved to be fired under that policy, they must prove that she was guilty of using an illegal drug.
Is illegal limited to state or federal?
Pardon me?
Is illegal limited to state or federal under that policy? Because you will acknowledge marijuana was still illegal federally in Ohio and West Virginia, everywhere, still is to this day.
Yes, Your Honor.
So in that sense, isn't it an illegal drug?
If you make that technical argument, although even DO Global has not advanced that argument in this case, I mean, there's state laws that clearly provide, and we're going to get to that. The state law that provided protection here ultimately to Ms. Daniels was a law that said, and it was in effect in West Virginia, it says you cannot fire someone for having, because of their status, of using marijuana in accordance with a medical marijuana card. That was the ultimate claim that
And at the time, nobody in West Virginia was entitled to those protections because there was no medical marijuana program up and running yet, correct?
that we were running about a year or two behind Ohio at the time. So at that time, there weren't dispensaries that were up. There was not the ability to obtain medical marijuana legally in West Virginia yet. That's true.
And she did not obtain any kind of certificate from West Virginia, correct? She had an Ohio.
That's correct, Your Honor. She could not, she did not have the ability at that time to obtain a certificate in West Virginia because they were not available. Her certificate was in Ohio. Her use of medical marijuana occurred exclusively in Ohio, and it was legal in Ohio.
And the reciprocity is limited to treatment of cancer, correct?
Pardon me?
Reciprocity between West Virginia and other states, including Ohio, is limited to the treatment of terminal cancer.
I'm not aware of that, Your Honor. I'm really not aware that wasn't an issue that was raised in this case. The reciprocity part of this, though, is I'm not familiar with that, Your Honor. But in any event, the defendant has contended that her status as an illegal drug user is dependent not on where she engaged in any illegal conduct. They've contended that her status as an illegal drug user depends on crossing a state line and working in West Virginia and being tested in West Virginia. For instance, if you consider, if she had if she had commuted to Columbus under these same facts, and she'd taken her return to work test in Columbus, they couldn't argue under any contorted theory of law that she was an illegal drug user because she would not have crossed state lines, and West Virginia law would have no application. And that's where we believe the Dormant Commerce Clause comes into effect. They are contending that her rights and her protections depended on the fact she crossed state lines. This is a discrimination against people on the basis of an interstate component of interstate commerce. According to their theory, an employee of theirs who lived in Huntington and who lawfully used medical marijuana under a West Virginia issued medical marijuana card would enjoy protection under the West Virginia Medical Cannabis Act, the anti-discrimination provisions. On the other hand, they contend that living in Proctorville, Ohio, and commuting to West Virginia, you enjoy no such protections. That you have the right to fire the person who legally uses medical marijuana in Ohio, but you don't have the right to legally fire the person who legally uses medical marijuana in West Virginia. We contend that that's a violation of the Dormant Commerce Clause. You're punishing people for crossing state lines.
Well, but under your argument, are you saying that West Virginia is obligated to accept the laws in other states in terms of their medical marijuana licensing?
Well, what we're saying, Your Honor, is that if you look at the statute, the anti-discrimination provisions that were in effect in the time under West Virginia's Medical Cannabis Act, there is no distinction made for where the medical certificate was issued.
That is if you ignore all the definitions in the act. I mean, you're wanting us to use the common sense definitions of terms that are defined in the act. I mean, medical cannabis is defined as cannabis issued under this program, and certified use is defined as under this program. So, I mean, when you look at this act fairly and the terms in that non-discrimination act, isn't it limited to marijuana under that program and use under that West Virginia program?
Your Honor, this legislature could have very easily, within the operative statute, said that the anti-discrimination only apply to people with medical marijuana cards issued in West Virginia.
But when they
It did
define,
not.
but when they define medical marijuana as issued in West Virginia, and they define certified use, as that means you're using it defined as a defined term, you're using it under this program in West Virginia, aren't they in essence doing that? I mean, when they define the terms that they use in the non-discrimination section as having to occur under the West Virginia program, don't they in effect stick in those words under this program through those definitions?
Well, Your Honor, I would respectfully contend they don't, because those specific operative words are not the ones that are being cited to in the statute. I understand DL Global's argument. We understand what you're saying, Your Honor. We contend that the statute itself does not limit it to people who reside in West Virginia, and if it did, it would be a violation of the Dormant Commerce Clause. That's our position.
Let me address that. There is a part of the statute. My colleague talked about several provisions that are clearly defined by the Act. One that he didn't mention is patient. And one of the criteria for patient is to be a resident of West Virginia. So at most, that might be your place for an argument, but I'm not sure that overcomes the definitions that my colleague referenced.
Well, Your Honor, again, we contend that if you look at the specific language of the prohibition, it cannot be fairly read, despite whatever definitions are being cited to limit itself only to people in West Virginia. And if that had been the intent of the legislature, they could have clearly added the appropriate words to make that clear.
Let me ask you about the statute, specifically under Section B, employment. And there are various exemptions or exceptions in B2, but without getting specific to those, B3 says nothing in this act shall require an employer to commit any act that would put the employer or any person acting on its behalf in violation of federal law. I'm not sure it's been argued, but how do you deal with the federal law that requires aviation-related employers and employees to undergo certain drug testing, both Department of Transportation, DOT, and FAA, Federal Aviation Administration?
Well, Your Honor, actually, that does come into play in this case, because one of the arguments that DA Global made was that as a matter of law, Ms. Daniels occupied a safety-sensitive position. And clearly, the FAA has established guidelines that advise employers like DA Global about who it is that should be treated as being occupying a safety-sensitive position so as to be subject to mandated drug testing. And despite the lower court's ruling as a matter of law that Ms. Daniels held a safety-sensitive position, the FAA guidelines, which we have included and cited in our briefing, specifically say the opposite. They say that people involved in ticketing and baggage handling are not safety-sensitive positions subject to mandated drug testing. Furthermore, Ms. Daniels worked there for 9 years. Never once was she told she held a safety-sensitive position. Never once was she subjected to mandated drug testing on the basis that she held a safety-sensitive position, nor were any other ticket agents.
Well, whether she was told or not, that's not determinative of whether or not she held a safety position. And I acknowledge your comments about the ticketing and baggage, although they raise the additional issue of preemption under the Airline Deregulation Act. But under these acts, my understanding is there's evidence that she did more, that she kind of screened passengers to see if there was a problem with them getting on the plane. And then she looked at a number of other issues that would be safety related.
Your Honor, the GEO Global witnesses in this case acknowledged that these employees doing what Ms. Daniels did had not been treated or were not recognized as holding safety-sensitive positions, that there were additional duties that had to come into play, and I don't recall specifically what those were, before they would be deemed to be safety-sensitive under the internal company policy. But nevertheless, there's a question of fact. I mean, at the very minimum, whether or not this was a safety-sensitive position was a jury issue. And there was plenty of evidence offered for which a jury could have reasonably concluded that this was not a safety-sensitive position. And just frankly, we filed a motion for summary judgment arguing as a matter of law that it was exactly the opposite.
Well, first of all, I think we may be guilty of confusing terms. The FAA concept of safety sensitive, is that the exact same standard delineated in TWIG when it talks about a job responsibility involving public safety or the safety of others? I mean, one comes from a state Supreme Court case talking about when you can drug test, and the other's an FAA designation. Are you arguing those two have to be synonymous?
I don't want to say they have to be synonymous, but I think there's every reason to believe they're talking about the same thing here. I mean, it's safety sensitivity, which means the job does certain things that create or may not create safety concerns, and the same things that are being addressed in the FAA regulations and bulletins as far as who does or doesn't fit those categories are the same considerations we would contend that were contemplated by the Twig case. So I know of no reason to conclude that the federal standard for safety sensitivity and the state standard would be any different. And certainly, there's no basis to conclude that any of the Twig exceptions were applicable in this case because there was not evidence sufficient to conclude as a matter of law that her position was a safety-sensitive position.
What evidence was there that her job didn't have, I mean, there was evidence, as I understand it, entered about screening passengers and the like that. What evidence to the contrary was there that, forget about how the FAA delineated it, what evidence was offered that she had nothing to do with public safety whatsoever?
Well, Your Honor, you can stretch the idea of public safety, and they paraded the horribles. I mean, some terrorists could walk in and do something, and a plane could blow up, and that can happen with respect to an interaction with it. But particularly, this is not someone who's flying an airplane. This is not someone who's responsible for making sure that the airplane is safe before it takes off. This is someone who's interacting with passengers as they ticket and check their baggage. Those are the primary responsibilities. And we contend that the FAA and West Virginia law would recognize that that does not rise to the same level as the other positions that the FAA would recognize are safety sensitive.
So were you disputing the fact that she had responsibilities? For instance, one of the cited things was to check if a passenger was intoxicated and not let them on the plane if they were intoxicated. Were you disputing that?
We did not specifically dispute that at the motion for summary judgment stage, Your Honor. That was not the basis of our argument. And frankly, the main basis of our argument here is it's a factual issue. And it should not have been resolved as a matter of law by the court when there's clearly evidence that goes both ways.
I guess that's what I'm asking you. What's the evidence that, I mean, you've told me that the FAA doesn't, you believe the FAA doesn't categorize it as that, and I understand that argument. Anything else that you have going the other way other than that?
Practice, 9 years of practice, 9 years of not recognizing that it was a safety-sensitive position, 9 years of not testing Ms. Daniels or any other ticket agent on the basis that they held a safety-sensitive position. We believe that's relevant evidence to show that this was not a safety-sensitive position, Your Honor.
You've used up your time. Thank you.
Thank you.
May it please the court, Laura Bunting, Jackson Lewis, on behalf of respondent. Where we choose to live, where we choose to work, has implications. This case is a good example of that. Petitioner Lisa Daniels was an at-will employee. She lived in Ohio, and she worked in West Virginia. She worked within West Virginia in a highly regulated industry where safety was paramount. Given those safety concerns, DAL's policies clearly provide that any potential impairment is unacceptable. And I'll talk about the safety risks when we particularly get to the invasion of privacy claim. But the policy says that an individual who has used illegal drugs, has the presence of illegal drugs in their system, results in a positive test, will be terminated. And that's what happened here. Timing is also important, just like where we live. In the fall of 2020, Lisa Daniels had returned from a 2-month leave of absence. She was cleared by her doctor with no restrictions at all. Come back to work, you're clear. At the time, and I'd be happy to read for the panel this provision of the Medical Cannabis Act, the default in West Virginia is that marijuana use, even if medicinal, is unlawful. That is the term that our legislature used. The default is unlawful. It's only if a person is certified appropriately under the act that they are covered. As an at-will employee, Ms. Daniel has a burden at step 1. Proof that she's covered under the laws under which she brings her claims. I will address for the panel that Ms. Daniels is not covered under the Medical Cannabis Act. She's not a covered individual under the West Virginia Human Rights Act. She likewise does not have a viable invasion of privacy claim.
Let me ask you at some point towards the end, but I'll give it to you now, although it may not be the basis of your argument. Want to see if your position is that under the influence is synonymous with simply having drugs in the system.
Your Honor, I'll submit DAL Global has no burden of proof in this case. Counsel said that DAL Global had to prove that Ms. Daniels had been under the influence at work. That's not what the policy prescribes. That's not what the law provides either. The policy for DAL Global says it's a violation for anyone to report to work under the influence of alcohol or with alcohol or illegal drugs in their system. Let's not forget that there are no tests.
Is that policy in the record? Can you cite me on the record where that is?
This is in the appendix. The Bates site is DGS 000315.
Thank you.
So is it your position that has been consistent in this case that you're not arguing that she was under the influence, simply that she had a positive test indicating that she had the presence of marijuana in her system?
That's correct, Your Honor. It's never been DAL Global's position that it proved in any way that Ms. Daniels was impaired at work. And there was some contention that in the record there was not any statement from DAL Global about the policy and that a positive test would result in termination. Counsel asked Michael James, and this is also in the appendix, it's page 60 of Mr. James' deposition. Counsel asked, "You are saying that if I test positive for marijuana, then the policy is that I should be terminated consistent with anyone else who would test positive for marijuana. Is that your understanding?" And Mr. James, as a company representative for DAO Global, replied yes. That is because the risk of anyone being impaired at work, they don't have to be impaired at work, but a positive result indicates that that risk is heightened for that individual, and that's not acceptable in the highly regulated aviation industry. Ms. Daniels is not encompassed with any of the laws. She filed a motion for summary judgment as well. There are no factual disputes. That argument's new to me here. The record on both sides was enough to submit to Judge Tabbitt. The law is what you need to decide. There is no reason for a jury trial in this case, and I'll submit that there's also no reason to overturn Judge Tabbitt's well-reasoned opinion. And here's why. I'd like to start with the Medical Cannabis Act. Some background's important here. It was enacted in 2017. The goal of the legislature was to put the law on the books because they knew it would take time for dispensaries to be certified by the government, for doctors to go through training and learn how and when they could prescribe and certify people for medical cannabis. Their goal was 2 years. There are 16 articles in that act. It's quite extensive. Each one has subsections as well. The provision under which Ms. Daniels seeks protection is one sentence within Article 15, and Article 15 covers miscellaneous provisions to the act. This is not an employment discrimination claim, and it's certainly not the thrust of the legislature's intent here. They very clearly define how, when, and who can be lawful users of cannabis within West Virginia. I'll submit to you, it makes no difference where Ms. Daniels consumed marijuana. DAL Global was not trying to paint her as a criminal, as was set forth in the petitioner's brief. But what we are enabled to argue and prove to Judge Tabbitt is the law doesn't cover Ms. Daniels in this particular situation, and here's why. This is not a law that all of a sudden said anyone who uses marijuana for medicinal purposes, that's lawful. That's explicitly not what the statute said, and here's why. Section 16A.3.3 is entitled Unlawful Use of Medical Cannabis. And this is why Judge Tabbitt's paragraph 50, which counsel referred to, is absolutely legally correct. The section reads, except as provided in Section 2 of this article, Section 4 of Article 7, Article 13 or 14 of this chapter, the use of medicinal cannabis is unlawful and shall, in addition to other penalty provided by law, be a violation of the Uniform Controlled Substance Act. Those articles don't apply here. They relate to people in academia performing tests and other things that are directly opposite to what we have here today. What that tells us is the legislature recognized two things. One, this is still a federally illegal substance. Two, they wanted to make narrow exceptions to that within the state of West Virginia for people whose doctors determined would benefit from cannabis. That's why the definitions are so crucial here when we look at the one sentence under a miscellaneous provision to see if Ms. Daniels has enough to legally recover against respondent. Patient is three things, key to which is a resident of West Virginia. That shows that our legislature, when taking careful consideration on this lengthy statute, did not intend to cover out-of-state certified marijuana users.
Let me ask you about that. Council made the Dormant Commerce Clause argument that has problems, I think, in this case. But one on that section, to be a patient, requires that you reside in West Virginia. Doesn't that, at least on that item, give him an argument?
It does not, Your Honor, and here's why. The Dormant Commerce Clause pertains mainly to taxation. He cites one case in petitioner's brief. It's a 2015 case that dealt with railroads and how fuel could be taxed as railroads moved throughout our states. Importantly, that case has been cited only once by a West Virginia court, and for a proposition that has absolutely nothing to do with employment, absolutely nothing to do with discrimination. It again relates to, in this case, electric cars and how taxes and tax rebates could be employed by citizens of the state. Ms. Daniels couldn't have been certified under West Virginia law. She wasn't. That doesn't mean that she couldn't lawfully use it in Ohio, but she can't seek protections under West Virginia law. There was some reference to Columbus, Ohio, and how things may have been different. This may have been different if we were an Ohio court, if we'd been arguing whether or not Ms. Daniels was afforded to protections under Ohio law. We're in a very different scenario. West Virginia law clearly does not apply for that count. Similarly, on the disability discrimination claim, this is an employment discrimination law, the West Virginia Human Rights Act. Individuals with disabilities can be covered. They need to be able to perform the essential functions of the job with or without accommodation. And here's why Ms. Daniels isn't covered and can't proceed on that claim either. West Virginia's Human Rights Act in our legislature has explicitly said that the act should not be construed to prohibit employers from, quote, making employment decisions based on drug test results. That's section 77-1-5.6. Cannabis was illegal in West Virginia at the time. Therefore, just like all other employers, DAL Global was entitled to use a positive drug test result as a basis for termination. And again, because Ms. Daniels was an at-will employee, DAL doesn't have the burden of proof here. Petitioner inappropriately tries to switch the burden of proof to DAL Global when she has not established coverage under the Act. Additionally, just like our federal law, the Americans with Disabilities Act, both the ADA and the WVHRA exclude individuals from definition of disability, in other words, people who could be covered under the Act if they are illegal drug users. And this is from our WVHRA. The term disabled does not include people, quote, whose employment by reason of such current alcohol or drug abuse would constitute a direct threat to the property or safety of others.
In the complaint, though, I don't think it's alleged that the disability is the drug use. I read that argument. I looked at the complaint. I think the alleged disability is cervical and lumbar issues. Isn't that a different argument than saying that drug use can't be the disability? Because I think they would acknowledge that the drug use isn't the claimed disability.
This is where it comes into play, Your Honor. An accommodation, if it asks for something that's illegal or not covered, is not something that can be permissible under the WVHRA. So if I understand petitioner's position, it is, please excuse me from a test for marijuana. Because we know that cannabis at the time, or marijuana, is not covered under West Virginia's law, cannot be considered a reasonable accommodation because it's asking for permissible use of an illegal drug, that's where the interplay with the disability definition, comes into play. You can't either be disabled or ask for an accommodation that runs afoul of West Virginia law. So do we dispute that she had some physical or mental impairments? No. That's a broad definition. But our statute has explicitly said both the testing can be used as a basis for termination, and if the accommodation or the accommodation for disability is for something that's illegal or not legally recognized, that doesn't afford an individual coverage under the statute. And here's why. Schaefer in the Fourth Circuit has found that an employee using drugs, quote, in the weeks and months prior to discharge aren't protected by the statute. That's important, although a Fourth Circuit case, because the law is very clear that the WVHRA and the ADA are analogous and are to be reviewed in a similar light. Ms. Daniels, this is not disputed, testified that she used cannabis the day she informed DAL Global, I'm cleared by my doctor, I'm ready to return to work. I'd like to next address, just very briefly, the retaliation claim under the WVHRA before I turn to the invasion of privacy as our last point. Petitioner did not address the WVHRA retaliation claim in her briefing on summary judgment. It's waived. We all know that the elements for retaliation claims under the statute and discrimination are very different. You cannot, by addressing a discrimination claim, say that you've addressed a retaliation claim. Even the burdens of proof are different. Retaliation requires but-for causation. I was only subject to an adverse action because I engaged in protected activity. Here, there's no protected activity that's been identified. Asking for an accommodation is not protected opposition activity under the WVHRA. It's not. Page 26 of the appellate brief by petitioner, I'll just point out, asked for a jury trial on this point. There are no disputed facts. No jury trial is warranted. And I'd like to conclude in my last 6 minutes talking about the invasion of privacy claim. West Virginia law does not have an outright prohibition on employee drug tests. I heard counsel reference practice as being important here. Practice is important. This is not an employer who goes around randomly, routinely, often drug testing Ms. Daniels. That shows that they recognize that drug tests are for specific purposes. In this case, the legitimacy of the purpose for a post-leave test is clear. There was some questions from the panel about safety and whether or not there was anything in the record to dispute that Ms. Daniels had key safety components to her job. I'd like to submit that in the appendix, there's even more evidence to bolster why safety was important and that Ms. Daniels knew it. At DGS 215, Ms. Daniels signed, and this is 2019, the year before her termination, a personal safety commitment letter. In there, it describes why safety is so important, which I'll submit to the panel is common sense for anyone who's been to an airport, especially after 9/11. It says that DGS, which is DAL Global, maintains the highest standard of business conduct and operates in full compliance with all applicable laws and regulations. We believe no level of harm is acceptable to anyone as a cost of doing business. Responsibility for the safety and security of our operation rests with every employee. And then it talks about how, whether managerial or not, every employee at DAL Global has safety responsibilities.
Specifically with respect to her, what job functions do you contend were safety-related functions?
Sure, thank you, Your Honor. And these are undisputed because they're taken from Ms. Daniels' testimony after I took her deposition. Someone comes to the airport. It's very crucial that an airplane is balanced. Weight of baggage is important. Ms. Daniels was the first line to weigh all the bags, to input that data, to give to the people who operated the airplane to ensure that upon takeoff, the airline is balanced. And one key witness, Ms. Daniels' supervisor in this case, Jennifer Kuhn, testified that this particular airport, Yeager, is at the top of a hill, and there's an even heightened risk, if a plane is imbalanced, of crash upon takeoff. She also screens for lithium batteries, which I'm sure we've seen in the news can cause explosions. And one thing that's crucial here is she is one of the only people allowed in secure airport areas. She was given a security pass to have free reign to the airport. She also, at the gate, is another line of defense. She has to ensure that individuals who are unruly, who are drunk, don't board the plane. She goes into the cockpit to liaise with pilots, if that's the case. She also, crucially, was tasked with an important thing. Individuals who check bags, historically, could check a bag, not board the plane, and have a potentially hazardous or explosive device or other item in their checked bag. Federal regulations say no passenger, no bag. She is the one who tells the airline staff, Joe Smith didn't show up in seat 22C. You have to remove his 2 checked bags. Those aren't trivial things. Those are important. Those are in the record, including Ms. Daniels, and this is at 219, application for her security identification display area clearance, that free pass to the airport.
The opposing counsel argues that the fact that these apparently weren't classified under the safety sensitive, under FAA is evidence, and the fact she wasn't drug tested is evidence that these aren't safety sensitive positions. Why is that not a question of fact?
The FAA prescribes that certain positions are so crucial that federal aviation law requires mandatory random testing. If you look at the policy, it does not say, here's the only group that can be tested, everyone else has no safety. There's interplay between the two. TWIGS only requires that an individual employer have a person in a position where the safety of the public or others is at risk. This is a heightened standard, okay? DAL Global has established in the record that every position is considered one where safety is important. That's been established through Ms. Daniels' undisputed testimony. There is no factual dispute that there's a higher level for FAA drug testing. But we're not dealing in this case with federal regulations as it pertains to Ms. Daniels. The only issue here on the invasion of privacy claim is whether or not the record establishes safety components of petitioner's job at the airport. That's clear and undisputed. And that means that DAL Global legitimately drug tested Ms. Daniels to reduce the best way they could potential safety hazards at the airport.
Let me ask you about what it sounds to be a concession on your part about the FAA, the DOT regulations. I mean, one of the categories listed for mandatory drug testing is aviation screening duties. But it sounds like some of the activities that you said are part of her job would constitute aviation screening duties. Why is it that you seem to be conceding that the FAA drug testing requirements don't apply?
That's inappropriately shifting the burden, Your Honor, to DAO Global. In this case, there's been some conflating of factual disputes here and factual records. DAO Global does not have to prove today to affirm and have the panel affirm Judge Tabbitt's decision that under federal aviation regulations, a customer service agent is one that's considered safety sensitive. I will point out, however, for the panel that our West Virginia courts have interpreted TWIG with other categories of jobs, again, not using FAA regulations, not using other regulations, for instance, particular to medicine, which are undisputedly out there to determine that safety is a component of a job and therefore drug testing is appropriate. Nurses have been determined to be safety component jobs. Firefighters, sheriffs, all in West Virginia, case law. Crucially, there have been at least one case, if you shepherdize TWIG, where a court has found, again, citing TWIG, that airport workers are people whose jobs have key safety components and who are appropriately tested, and in doing so do not violate the privacy rights of employees. That's what we have here, an individual who went out on leave, knew she was going to be tested to return. There was no surprise, which lessens any potential privacy arguments in an undisputedly risky work environment where safety deviations could not be accepted by the employer. My time is up. I'm happy to answer other questions, though.
Quickly, a couple questions. In terms of the FAA DOT testing, is there a particular reason why you didn't argue that it's preempted? Is it because you don't feel that you need to get into establishing whether or not it's an FAA safety-sensitive position? And then similarly related is the ADA, the Airline Deregulation Act, also preempts laws that affect, among other things, services provided by an airline and those associated with it. I'm just curious why preemption doesn't appear to have been an argument raised by your client.
Your Honor, we submit that it was most appropriate at the trial court level and as well here to place the burden on Ms. Daniels. I do agree that preemption has been argued in these cases. I've argued preemption when, for instance, a jail employee at a federal prison had a medical marijuana certificate in Pennsylvania. In this case, I think it's best to just keep the focus on the undisputed testimony by Ms. Daniels about why safety was so crucial to her role. We didn't think that it was necessary to get into the heightened preemption argument because West Virginia case law is clear that all that's required, and this is from our West Virginia court, where a business is engaged in an activity which involves either public safety or safety concerns for others, we find that there exists a legitimate reason for a drug testing policy, since a drug-impaired employee would potentially increase the risk of harm to others. That's what we have here.
In terms of preemption, if a preemption applies, does this court lack jurisdiction, and did the lower court lack jurisdiction to address these issues?
Your Honor, preemption is an issue that can be raised sua sponte by any court, similar to jurisdiction. I certainly think it may be appropriate in this case, but we focused our arguments because TWIG was the only contention to support the privacy claim at the trial court level by preemption on TWIGs and the clear mandate that if safety is involved, testing is permissible.
On TWIG, there's two
arguable bases to allow drug tests. One is the safety, the other is the Bauman or Bowman, I'm not sure how you pronounce that, Bauman versus Walmart cases where the pre-employment drug screening was allowed in that case, although there was an admonition not to extend that any further. But you're also arguing for an extension of Bauman, I think, to equate that here where there's a return to work. Is that correct?
Your Honor, yes, and we would submit that it's not explicitly an extension of Bauman, given DAL's policies. The drug testing policy for DAL explicitly provides that employees who are returning from leave are treated in many ways like a new applicant. Many employees who go out on leave never return. When they do, there are additional screening mechanisms pursuant to DAL policies that are required. And that's why I would submit Bauman's appropriate here. It's similar to an individual who took leave for personal circumstances having nothing to do with the employer and of his or her own volition decided to return. That's why when DAL's policies come into play here, they prescribe that, quote, employees who have not worked for 30 days must also complete drug testing before returning to work. That's why I submit, Your Honor, Bauman in this case is not an extension, but it's treating an individual who returns post-leave akin to a new applicant.
Would you be saying that a pre-employment screening essentially is pre-going to work screening?
Pre-employment screening would be the first time someone onboards at an employer to ensure that they have the necessary qualifications, skills, and similarly are free from the presence of illegal substances. An employee who is out more than a month and decides to come back, in this case, Ms. Daniels was away from work voluntarily, she asked for it, and it was approved for more than 60 days. That individual is more akin, Your Honor, we would submit to someone who was applying for the first time. We again needed to make sure they were free from criminal records. They didn't have the presence of illegal drug use, given that absence from work for that period of extended time.
I think we understand your position. Thank you.
Thank you.
Mr. Hensmeyer, you used your time, but we've been generous and we'll give you a few minutes.
Well, Your Honor, just a couple of points. First, I want to address the Bauman case because we do not believe that there's any appropriate basis to extend Bauman to these circumstances. By the way, when you say that she went out of work voluntarily, she went out of work because she had a medical condition that required her to go out of work. She didn't go on a 6-month vacation to the Bahamas.
It was not a workplace injury, though.
It was not a workplace injury. It was a medical condition for which she was required to be on leave to get treatment. But in terms of expectation of privacy, this is an employee who's been there for 9 years. She goes out on leave. We contend that when she comes back, she has a greater expectation than the person who is applying for a job, has no pre-existing relationship with this employer, and who, if they don't like the idea of mandated drug testing, they can move on to the next application. This is an employee who has a job. Her livelihood depends on her ability to come back. She doesn't have any choice in the matter. She's going to take this test, and so therefore, that's why we contend there's very much a difference of expectation of privacy in Ms. Daniels' situation than there would be for a new.
Is the expectation of privacy affected by the fact that they got a policy telling them that when that happens, you're going to have this test? I mean,
Well,
how's there an expectation of privacy if the policy says this is what's going to happen?
Well, you know, it's an interesting question, but bottom line, the argument is being made essentially that if we have an unlawful policy that requires you to be tested, then you should have an expectation you're going to be tested, and your privacy expectations somehow are lessened because we're doing something that we shouldn't be doing. I mean, I would contend that the expectation privacies aren't tied to whether or not the employer is forcing upon you a test, but rather upon your circumstances, which in this case are, hey, I'm out. By the way, she's out on medical leave, which is a highly confidential type of circumstances. We have HIPAA laws. We have all kinds of reasons to protect people's privacies that's associated with the circumstances she was in, which was being treated for a particular medical condition. So we would contend in that sense, she has a greater expectation of privacy than someone who's continuing to work. But, you know, that would be my response to your question. You know, any other specific questions?
I think we understand your position. We thank you very much. The case will be submitted.
Thank you, Your Honor.